Okay, our next case is Timothy Smith versus Kimberly Mayers as the personal representative of Robert Jane Mayers III. And Ms. Perry, would you like to reserve any time for rebuttal?
Yes, Your Honor. May it please the court, my name is Allison Perry, and I would like to reserve 5 minutes for rebuttal, please.
Yes, ma'am, you may proceed.
Okay, this case involves, excuse me, an order granting summary judgment and a final eviction based on that order. So the standard of review is de novo by this court. This case involves a lease in between the appellant, Timothy Smith, and his deceased stepfather, Mr. Mars, that was entered into in January of 2002. The terms of the lease allow Timothy to remain in the property as long as he maintains the property.
So the trial court found that this was a perpetual lease, correct? And
Right.
then that became an illegal restraint or an unlawful restraint on alienation of the property. Am I correct on that? And so one part of the lease allows a renewal for as many years as desired. And as I understand your argument, you say, well, that at some point will terminate.
It will have to terminate upon his death or
Upon his death. What about the fact that this lease also allowed the tenant to assign this to his heirs or assigns?
Well, that's just superfluous language.
I mean, it's part of the lease, correct?
But,
so
the lease requires him to reside there. And another point is that that's not the grounds that the court found it to be void. The court found it to be void because of term 3, paragraph 3, and paragraph 22. It did not consider the paragraph 24.
But answer my question, if you can.
Okay.
Not what you're saying the trial court did.
Okay.
If he has the ability to assign this to his heirs, and then they have the ability to assign, then doesn't that make it perpetual? Isn't it arguable it's perpetual at that point?
No, because because the term says the lease shall be binding upon and for the benefit of the heirs, personal representative successors, and permitted assignees, so it has to be permitted, of landlord and tenant, subject to
Isn't there an assignment? It says, unless this box is checked, tenant may not assign this lease or sublease in provision 9, and then the box is checked.
Box was checked.
So tenant has the ability to do that under the language of the lease,
it has to
correct?
be permitted. I guess you're saying that means it's permitted. But it's subject to the requirements specifically mentioned in the lease. And in the lease, the term is that the lease is for a term of 12 months beginning on January 3rd, 2022, and ending at such time as a tenant no longer chooses to occupy the premises. So he has to occupy the premises. That's the term of the lease.
So if you assume that we agree with you on the interpretation of the lease, I'm wondering how this is still a marketable property. What would be your sales pitch?
It's not. It's like a lifetime.
To a prospective buyer, right? So somebody's going to come buy this property encumbered by this lease as you understand the lease, right? What is your sales pitch to the prospective buyer as to why they should buy the property and what it's worth?
Because it's only going to appreciate in value. The lessee has the motive to improve the property because he gets the enjoyment of the property while he's maintaining the property.
But the lease says that the landlord bears like the lion's share of the maintenance obligation, and there's no rent that's paid.
Right,
Zero,
but there's
right?
Right, correct. But he has to pay the utilities, and he also has to maintain the property. And
part of his maintenance of the property is taking out the garbage, pest control, termite control, but roofing, expensive maintenances of the property fall to the landlord.
Correct. But Florida allows such life estates as this all the time.
Well, let me ask you, if you say does this actually meet the formalities of a life estate?
I believe it does.
Okay, do you have any legal, other than you believe, do you have any kind of legal, any case law, any kind of statutory law that says this is a life estate? I mean, because he's paying no rent and he pays no taxes, which usually under a life estate you're going to take care of the taxes. So I'm just wondering how this lease, if this can be called a life estate.
Okay, this is more akin to the case where the parents left their children, let me see, hold on a second. The Johnson v. Gertman case, which is in my initial brief, and that's at 452 Southern 2nd, 1033. It's a Florida 3rd DCA case from 1989. It was overturned on other grounds by the Florida Supreme Court. But in that case, the grantor conveyed to their children fee simple estate of the house to their children with the condition that the children leave their share of the house to their children. So, in fee simple. So they basically wanted to leave it to their grandchildren eventually. Now, the court said the restriction was no more repugnant to the public interest than the granting of a life estate to the Gertman children with a vested remainder in the simple to the grandchildren.
So you say the trial court relied on the PV case, correct? That's from our court?
Yes.
That's from our court. And you say it does not apply
It's
here.
that does, Gertman?
PV, the PV case.
Oh, PV case does not apply.
Okay, yeah, but I mean, that's from our court, correct?
Yes, that's
okay,
more
and
important
so the
because
trial
it's-
court relied on the PV case, correct?
Yes.
Okay, and why does it not apply?
Because that is for an unlimited period, because in that case, the lessee was a corporation, and
Did
corporations...
the PV court talk about the fact that it was a corporation?
Yeah, yes, they talked about it was a corporation, and
That was the basis of their decision, or
that it
as,
would go on indefinitely.
or as Judge Pratt said, dealing with the market, and I know he didn't mention the PV, but he raised the issue of the marketability of the property. Wasn't that a
Correct.
focus also of PV?
Yes, that was also in PV, talking about the marketability of the property, and also that
Was there
was
anything
no...
in this lease that precludes the tenant from assigning, without the landlord's consent, the lease to a corporation?
He has to occupy the property, so if he occupies the property, I guess during his...
Why couldn't he set up an LLC and transfer it to the LLC and then occupy the
Because it has to
property?
be a permitted assignee, and I don't believe that
But the landlord's consent is not needed to make an assignment. And a corporation can occupy a residence, right? A representative of the corporation could live there and cut the grass, right?
That's true.
Okay, so, I mean, I'm just trying to imagine, again, going back to marketability, which, is really what the test on, restraints and alienation focuses on. I'm just wondering what the sales pitch is. Like, who wants to buy this house, right? There's a guy who lives here. He doesn't have a whole lot of responsibility. He has to maintain it other than the really big ticket stuff, so he does the small ticket maintenance. He doesn't pay taxes. He doesn't pay rent. Oh, and by the way, he can assign the lease to anyone he wants to without consent of the landlord, which might even include a corporation. Who's the buyer for that house?
Well, one, I disagree that he can assign the lease to anyone. I think the language of paragraph 24 says it's subject to the requirements specifically mentioned in the lease. And specifically mentioned in the lease over and over again is that he gets to stay in the property as long as he chooses to occupy the premises.
He could, again, as Judge Pratt said, he could set up an LLC, assign the property to this LLC, if he was even a member of the LLC, and live in the property, correct?
I think we're losing sight of like the original intention. The intention of the lessor of this property was a stepfather who wanted to leave a property to his stepson for his lifetime.
But when we look at intent and contracts, we look at the language. He's not here to testify and tell us, what he meant, and it's not really our job, I don't think, to try to, after the fact, climb into his head and try to figure out what he's thinking. What we have are the words on the page, right? We have a lease that we have to construe, and we have the supremacy of the text. We have to look to the text. The text is the evidence, the probative evidence of what the owner sought to convey. And, again, I mean, I'd appreciate, an answer to Judge Boatwright's question.
Marketability.
How is that outside the text of the lease? Maybe
Okay.
that's a different rephrasing.
Well, to get to your question on marketability, their life estates are given all the time in Florida. And Florida law permits restraints on alienation that are limited. That's the law. That's Johnson v. Gertman 542 Southern 2nd at
I think we understand you're
1035.
I think we understand you're allowed to give a life estate. So is there any testamentary documents other than this lease that indicated his intent, either in a trust or in the will in this case, that would have indicated his intent that this was supposed to be a life estate?
Actually, the affidavit that was attached to the response from the appellant
I'm
stated...
talking about would have been from the testator himself, the decedent in the case.
There's a missing will, is my understanding is there is a missing will.
So that could still be flushed out in the probate case as far as whether or not he was entitled to a life estate in this property through a will, correct?
Yes.
Okay.
Now, importantly, the court ruled that paragraph 3 and paragraph 22, they found the lease is clearly a perpetual lease, as outlined in paragraph 22. Because of the renewal and extension, the lease automatically renews and extends for another year and for as many years as desired by the tenant until the tenant, at his sole discretion, shall cancel this lease. And it says his sole discretion. So it shows that they wanted it for him, his discretion, not a corporation, not some assignee. It's for his sole discretion. So that term right there, his sole discretion, those terms together show that the intent was to give this to Timothy for his sole discretion. So that his is very important because that couldn't be a corporation, it couldn't be a she, and I believe it shows that there was no intent, there was an intent to leave this property to Timothy for a life estate.
Doesn't an assignment of a contract assign all of the rights and responsibilities under the contract to another? Isn't that what an assignment is?
If it's assignable, and I don't think this contract is assignable because of that term, and also because it says that it's subject, that the assignability is subject to all the other terms of the lease, and the terms of the lease require him to occupy the property.
Right, but wouldn't the assignee be required to occupy the property, right? Because it is a responsibility of the lessee under this contract to occupy the premises, right? And if the contract, the lease is assigned, right, doesn't that occupancy responsibility fall to the assignee?
I disagree because I believe this lease, based on the language, it's his sole discretion. He has to occupy the property, and as soon as he doesn't elect to occupy the property anymore, the lease is terminated.
Right, but
So
the his that's identified is the tenant, and someone to whom this lease is assigned becomes the tenant, yes or no?
I just don't think this is an assignable lease because of by him on his term. The tenant cannot assign this lease because it's specific to him and the terms of the contract. And remember, the court didn't rely on that to reach its decision. I understand the tipsy coachman doctrine, but the tenant subject to the requirements specifically mentioned in the lease. So the specific terms of the lease control over this miscellaneous section. It's in a miscellaneous section for a reason. It's not. It wasn't considered the heart of the agreement, and the lease clearly the lessor wanted his stepson to have a life estate or something similar to a life estate as long as he wanted to occupy that property until his death or departure from the property. So that's all I have.
Okay, thank you.
Any other questions?
I don't see any. Thank you.
Thank you.
Okay.
Good afternoon, and may it please the court. Alyssa Corey of Schutz & Bowen on behalf of the landlord. The trial court correctly determined tenant's lease was void as an unreasonable restraint on alienation or alternatively, that the lease properly terminated after a single renewal term, and as a result, landlord was entitled to summary judgment as a matter of law, and that decision should be affirmed. On appeal, and as has been discussed at issue, tenant suggests that the lease is of a limited duration and takes issue with the trial court's analysis of the lease's renewal clause in Section 22.
Let me ask you, if we were to interpret the lease as Ms. Perry states, that this was just for Mr. Smith's lifetime. Judge Pratt's raised this issue. Marketability, the restraint against alienation, do you think that would still apply in this case? Let's say Mr. Smith's going to live another 20, 30 years.
Correct. And I think the closest case that kind of gets at that discussion is in Thompson versus First National Bank from the 4th DCA in 1975, where there was a lease period and then a subsequent amendment to that lease that then extended the lease term in total for 70 years. In that case, that reasonableness analysis determined that there was no perpetualness of that lease because there was a fixed ending period here. And while the tenant seems to suggest that the death would be at some unknown time a fixed ending period, that's not consistent with the terms of the lease in Section 24.
But if it were, would this then be considered a unlawful restraint of alienation at that point? If there were some fixed point, let's say 20 years, 30 years, I mean, I don't know how old Mr. Smith is, but let's say 20 years down the road. Because Judge Pratt raised the issue, as I understood, regardless of whether it's perpetual, at some point it could be so long that the marketability is affected.
Right,
I mean,
exactly.
He's not paying any rent, not paying any taxes. So, I mean, is that supported by case law that a long-term lease in something in this form is still an unlawful restraint of alienation?
That's correct, because Florida follows that common law rule that unreasonable restraints are void, looking at the reasonableness of the restraint itself. So that is going to be a fact-specific case. The rule of unreasonable restraints really focuses on the alienation through the lens of the long-term effect of improvement and marketability of the property. And so we've got those public policy considerations and the idea that the free alienability of property fosters economic and commercial development.
Why couldn't a hypothetical buyer look at this property and say, my general counsel's, every home buyer comes with a general counsel. Joking, obviously. I know that's not true, but hypothetically, my general counsel says, there's a pretty good argument this lease is really, subject to renewal every year. And worst case scenario, it's only going to last for as long as this tenant lives. Ordinarily this house might be worth X amount, but if we dock it, the tenant, let's say he's X years old, we think he's going to live for Y more years. Let's dock from the home price whatever we think Y years is worth. Yeah, maybe I'll buy the house. I mean, are you saying that there is no such buyer, or is that the test, or is the test, that there has to be, a reasonably sized market for the property, right? Because you can always find at least one buyer who's willing to buy anything, right? There's a price for everything, they say. Why doesn't this home have a price, or is the test instead that the home should have a price for a reasonable, sized market?
Yeah, and I think when we're looking at the factors in PV that is instructive to your question, we were looking at a fixed term for, $600, $650, $700, and then it would increase for $50. And as noted in PV, few people would be willing to purchase a property which they might never have the right to use other than to rent it at a predetermined rate. And at least in PV, there was rent that was being received. Again, the lease at issue has the potential to prevent landlord from being able to utilize the property for any purpose.
Does PV even apply here, though? I mean, appellant's counsel claims that PV doesn't apply because the lease is not to a corporate entity.
And PV may have involved a corporate tenant, but the reasonableness test that was applied originated from Englehart versus Phillips, which is a deed between a father and a son, does not involve a corporate tenant and has been applied equally to non-corporate tenants, and has been discussed by Judge Pratt. The lease involves and allows for permitted assigns without restriction. That could lead to tenant potentially assigning his interest in the lease to a corporation. Tenant essentially asked this court to ignore Section 24 and the permitted benefits and assigns. But indeed,
why is this not just a life estate? Why shouldn't we just treat it as a life estate?
As an initial matter, the life estate construction of this lease was never presented to the trial court. The way that the tenant framed that argument below was allowing for lifetime renewals. Lifetime renewals under a lease is certainly much different than purporting that the lease conveyed a life estate. This has been discussed about the probate case that's ongoing, and what may shake out in that case.
The probate case is still proceeding?
The probate case is proceeding, but the tenant dismissed its claim against the estate a week before trial. So there won't be any further determination on that basis. And when talking about the life estate, the Johnson case that was discussed is just factually distinguishable in that discussion about a will and the validity of the surrounding circumstances of that conveyance. Here, agreements to devise property by will must include sufficient consideration. There would have to be an analysis of whether no rent and limited maintenance is sufficient consideration. It has to be in writing and contain the same formalities of a will in writing to witnesses. None of those conditions are present in the lease at issue, and this can't be construed out as a life estate, even if it's deemed to be preserved as presented before the trial court.
Just going back to the nature of the applicable test, if we could, as a court, hypothesize an eclectic buyer that would find some value in a property, would that be sufficient to defeat a unlawful restraint on alienation claim, or does there have to be a higher showing that it's more than just a single eclectic buyer, but there's some sort of market? And how do we gauge the size of that market? I'm just curious, what is the test that we're applying? How do we flesh that out? Because it occurs to me that there may be for any given eclectic property, one eclectic buyer that might find some marketability in its title. And I'm just curious what your take is on the test. What's the test that we're applying?
Yeah, so the test for looking at the validity or invalidity of the restraint, as we discussed, looks upon the long-term effect of the improvement and marketability of the property. And then once that effect has been determined, we've got all of the factors on time, how much rent, is it fixed, is it floating?
No, I understand all that, but I'm just, marketability to whom, right? If you can find a buyer, one eclectic buyer, is it marketable? Or do you need more than one eclectic buyer? Do you need, and then what is the size, right? I mean, there are homes that are marketable to everybody. There are homes that are marketable to a few. There are homes that are marketable maybe to only one or two, right? What is the size of the market that needs to be shown?
And as this test has been applied, then they say common sense should dictate whether it's reasonable or unreasonable. Testing
So
out.
the test would be reasonableness under PV,
Right.
would it not?
Yes. And so, we're looking at whether the restraint as analyzed through the lens of the conditions would be reasonable or unreasonable. So looking at your hypo, Judge Pratt, I would say if there's one eccentric buyer that is okay with a corporation taking over this property, for a term as long as it chooses to occupy the premises and until at its sole discretion cancels the lease, sure, there might be one buyer out there that agrees with that. But when we're looking at the validity of the lease and whether the terms are perpetual and present an unreasonable restraint on alienation, we've got to exercise that common sense application. And then, of course, here we're looking at two alternative bases. The court, determined that the lease provisions are void because of this perpetual nature, but also we have to look at the additional basis where there, say there is, we talked a lot about intent in the argument and what was the intent of the stepfather, who passed 9 months after this lease was executed. And, we have to say the trial court looked at this in the light most favorable to the tenant, construing the lease as providing for a 1-year renewal term as opposed to being void. So the trial court in the alternative determined at most if the lease renewal provision is construed to not sufficiently establish that clear and explicit right of indefinite renewals, that the lease was properly construed to entitle tenant to 1 renewal period. If there's no further questions.
Okay, I don't see any. Thank you, ma'am.
Thank you. This court should affirm the grant such room judgment.
Ms. Perry, any rebuttal, ma'am?
Yes, Your Honor. Okay. So Iglehart is where the Florida Supreme Court, or this is from the order granting summary judgment, and the court found that Iglehart, where the Florida Supreme Court found that this type of lease gives the landlord little incentive to make improvements on the property and puts into question whether the landlord would even be able to sell such an encumbered piece of property to a third party. But Iglehart had to do with a deed restriction, a repurchase deed restriction. So he could never sell the property without having to give the right of first refusal to, it was the father.
All of these cases, though, as Judge Soud, really focus around this reasonable element. That's
yes,
correct?
The reasonableness.
Okay.
Now, remember, Florida law permits restraints on alienation that are limited. So limited like lifetime estates, which are done all the time. As long as a restraint is not repugnant to the public, and here it would not be repugnant because it is like a life estate. And that's the Johnson v. Gertman case that I already cited to. And this is clearly an intent of the stepfather to leave his stepson a property to live in during his lifetime, and this court should reverse.
Thank you.
Thank you so much.
Okay. Very well argued case by both of you, and we are finished for the day, so we will stand in recess.
Thank you.